Back with us, Adam Klasfeld, Lisa Rubin, and Andrew Weissmann. So, Donald Trump, I've been saying, forever, Donald Trump will never testify in his own defense in a criminal trial because he obviously would commit perjury if he did that. He'd also be a terrible witness. He would be found guilty, absolutely, based on his own testimony. Today, Donald Trump agreed with me, and he admitted he didn't testify in this case because he would have committed perjury. Let's listen to Donald Trump say that.
Now, I would have testified. I wanted to testify. The theory is you never testify because as soon as you testify, anybody, if it were George Washington, don't testify because they'll get you on something that you said slightly wrong and then they sue you for perjury.
Okay, Donald, first of all, George Washington did testify. He testified against himself to his father when he was 6 years old, said, "I cannot tell a lie. I chopped down the tree." Andrew Weissmann, we're going to hear this for as long as Donald Trump is able to speak, and we will hear it in every other one of his criminal trials about how he wanted to testify.
Donald Trump had a right to testify. Judge Merchan made sure he knew it because early in the trial, when Donald Trump was saying because of the gag order he could not testify, Juan Merchan wanted to make sure that Donald Trump, the former president of the United States, understood the rights that any defendant has. And it is a right that is personal to the defendant. It is not a right that is exercised by defense counsel, as all of those defense counsel know. And that is, it is the defendant's choice to testify or not to testify. So it is simply a lie if he says I was, prohibited from testifying or I wanted to testify. If he wanted to, he could hop on the stand and testify. He could have called Keith Schiller if he wanted to. He could have called Alan Weisselberg in the same way he made a choice to call Bob Costello. Not the best choice in the world, given how that went. He also was free to cross-examine David Pecker and to say he was a liar. He did not. David Pecker was, as Lisa said, was close to the defendant. He was a key witness. He could have cross-examined Hope Hicks and said she was a liar. He did not. She provided equally damning testimony. The same thing for Jeff McConney, and on and on. What are all of those witnesses who did testify have in common? They were all people loyal to and aligned with Donald Trump. So for the people who say this was a witch hunt and it's unfair and it's a sham, these are Donald Trump's friends and allies and employees who testified. They were not even claimed to be lying by Donald Trump. And he had a choice to testify and to call witnesses in addition to Bob Costello, and he chose not to.
So it's one thing for Donald Trump to say something as absurd as that. It's something else when Donald Trump's lead defense lawyer, Todd Blanche, goes on CNN. And we're going to show you what he said. He had a tough time in the courtroom because he had bad facts. He's having an even worse time on television. Todd Blanche, by the way, has a permanent invitation to come on this program whenever he possibly can to answer questions about this and the other Trump cases. Let's listen to what he said, what Todd Blanche said on CNN.
Why didn't the defense call any of these witnesses?
Well, because we happen to live in America and we don't have the burden of proof. And so there's not, that's not the point. That's a question that is a loaded question that should not be asked of a defense attorney or a defendant. The question that we asked the jury, and they ultimately obviously got passed, is why the prosecution didn't call those witnesses, right? You, as a defense attorney, you don't go into a case saying, I'm going to fill the holes of the prosecution, right? And Keith Schiller and some of the other witnesses that were not ultimately called, in our view, should have been called by the prosecution.
Lisa Rubin, this is a level of silliness now that is just beyond what you could expect from any serious lawyer. He lost the case. He lost it. And he didn't call these witnesses. And he obviously didn't call these witnesses because he thought they would do damage to his case.
And he said as much on CNN. I saw that clip earlier today, Lawrence, in part because Andrew called my attention to it through a tweet. And the first thing that struck me was the arrogance of because this is America or because we live in America and we don't carry the burden of proof. And yes, that's true. They didn't have the burden of proof. But if they wanted to show the jury that the prosecution didn't meet its burden, they had any number of means to try and demonstrate that. And their answer was solely Bob Costello. As for the rest of his statement, he told on himself when he said, it's not our job to fill the holes in the prosecution's case. That's a concession that had they called Keith Schiller or even the convicted perjurer, Alan Weisselberg, on his second stint at Rikers Island right now, that those people would have aided the prosecution. Saying it's not our job to fill the prosecution's holes was like a staggering admission from Todd Blanche, who I just was gobsmacked by seeing that interview.
Well, you know, Adam, he had a tough time in the courtroom, and I sympathize with lawyers who have bad facts. I sympathize with lawyers in courtrooms who have, you know, there's just nothing they can get up there with and use. They don't really have ammunition. But to get into this freewheeling discussion on CNN and to say that's a question that no defense lawyer should ever be asked. Are you kidding me? That you can't ask a defense lawyer whether he should have called more witnesses?
It didn't make sense. And, you know, Lisa said it all with that. So, you know, I will say one of the most surprising things with me, kind of going back to the trial, was Todd Blanche wasting so much of his time and credibility on the patently absurd argument that these were not reimbursements, after his own client had said in two sworn statements seen by the jury and a tweet that these were reimbursements. That he said that even after there were those two smoking gun documents, he wasted so much time and so much credibility with the jury. With that, it was a pivot point of both his opening statements and his closing arguments. And the fact that that was a pivot point of his defense, I think, may explain the speed with which the jury rejected reasonable doubt.